We're ready, Chair.
Good morning, all who are online or in the room here in Salem, Oregon. It's 9 a.m. on July 11, 2025. So using a gavel, I hereby call to order this meeting of the Oregon Government Ethics Commission. Our Executive Director, Susan Myers, is in the Salem office with staff from the Investigative Training and Administrative section of the Commission. Our counsel from the Oregon Department of Justice, Sean Brady, is also in the Salem office. And for the record, my name is Dave Piscom, and I currently serve as chair of the commission, and I am in the Salem office. As for other commissioners, Vice Chair Shanoa Payne is unable to attend this morning, so I have asked Commissioner Jonathan Thompson to function as acting vice chair. And speaking of Commissioner Thompson, he is in the Salem office. Commissioner Dan Mason is online. Commissioner Rick Burke is or will soon be online. Commissioner Alicia McCauley is online. Commissioner Ivan Resendez Gutierrez is online. Commissioner Peter Jancy is online. Commissioner Ann Metler will be able to join us about an hour from now. And otherwise, just as a generalization, a couple of our commissioners thus named have minimal, small conflicts today, and maybe leaving at a point and then coming back for the rest of our meeting. So we'll deal with that as it happens. This attendance means we have a quorum, so we will proceed today first with a few items on our public session agenda, and then moving into executive session. As chair this morning, I do not have any comments to make for the record, but the agenda for the public session also allows for comments from commissioners on subjects not on the formal agenda. So the question is, are there any takers this morning? Hearing and seeing none, let's move now to the public session agenda. And the first items on that agenda that we intend to consider today are item number 3 and the 3 components of same, and then we'll deal with the minutes after that. So for the work session, this is titled work session, at least in part because action is not required by us this morning, but our executive will apprise us of these issues, and we thought it was important for all of us to hear these comments today. So we're starting with this on our public session agenda. Executive, please proceed.
Thank you, Chair. Commissioners, the first item in the work session was kind of a continuation of the discussion we had in April about what is the role of a complainant in our process. And the reason I added this back is at last month's meeting, there was a case where someone asked a question about, well, who was the complainant in this case? Why did they file? And while you are, of course, always entitled to ask whatever questions you have afterwards, because we then identified the complainant, we received a number of emails from the community about, well, that's unfair and so forth. Now, they can think what they want. But I go back to what kind of we discussed in April, which is, while the respondent may have opinions about this person, why did they file a complaint against me? From our purely legal perspective, it's irrelevant. I mean, all we're trying, at least I and the investigators, is figure out what happened and apply the facts and the law together to find out whether there's a violation. I understand the commission's sort of curiosity, but I also want to re-stress that really other than filing the complaint, the complainant has no standing, does not play a role.
Before the executive moves on, let me just make sure, see if there are any questions about what she has said this morning. In case there are, this is the time to ask them. I just have one quick comment before a question, if there is a question, that is that we do not accept anonymous complaints. So the identification of the complainant is at least by name only on all of our documents, not anonymous. So beyond that, you're saying that the complainant has no quote, standing, unquote. And if we ask a question about who a complainant is, that is okay, but not necessarily relevant. Is that the way to put it?
Right. You asking who the complainant is doesn't give the complainant standing. So that's not the concern. And certainly you are right. The name is identified in all the documents. So the folks in the community who are, suddenly saying, oh, how could you identify them? Not the strongest argument out there.
Council, any comments on this for us? And if you don't, that's okay. I just want to make sure that we've considered your viewpoint if you have a viewpoint to add to our perspective.
No, I would agree. It's not who the complainant is not relevant to whether or not there's a violation. So
fair point.
Yeah.
Thank you.
Yeah.
Colleagues, any questions quickly on that subject? If there are, now's the time. Hearing and seeing none, please proceed.
So this was the more substantive discussion for the work session, which is class exceptions. And Commission has asked several times in the past for some clarification on how class exception arguments should or are being brought to them and how they should consider them. So for there to be a class exception, the person alleging it, who otherwise would need to disclose a conflict, needs to be a member of a class as determined by the commission, basically. And then there needs to be a determination that all members of the class would be affected to the same degree by whatever decision or action is being taken by the public body or the person. The dilemma, of course, is one, having a determination of whether this person is a member of a class. Now, the easiest and cleanest way for that to happen is for someone to write in and ask for a commission advisory opinion where the commission then is making that determination. The problem is that can take 60 days, sometimes longer, usually not. And they usually want an answer within a few days. So their options, they can choose to proceed under their belief that there's a class exception, but the risk there is the commission could determine otherwise. In which case, they would need to have disclosed their conflicts. The alternative, the other part of this is when it is a case that's before us and someone's saying, oh, I was a member of a class, I didn't need to disclose. How should the commission make that determination? Well, in a PR period, 60 days, most of the time we would not have sufficient information to present to the commission in terms of identifying whether they're a member of a class and then determining if all members of the class would be affected to the same degree. So they can bring it up in PR, of course, in their response. But in those cases, we usually would say we would need time in an investigation to really look into the issues and bring it back to the commission in the investigation report. We've had reports that then say, looking at this, it does appear this person would be a member of the class. For example, I think it was last month or the month before, we had that question of whether this public official was in a class of homeowners who would be affected by the community fee, community development fee. And in the investigative report, the answer was yes, that you would be part of that class, but not part of the class as a property developer. So I don't have a good answer for you right now in terms of, can we get that information to you at the PR stage? To the extent that we can, we would try, but most often I think it would require going to investigation so that we can answer the necessary questions.
Thank you, Executive. Colleagues, any comments or questions? I've got a quick comment in a moment, but I'll yield to the acting Vice Chair, Jonathan Thompson.
Thank you, Mr. Chair. I have a question as this relates to members of the legislature. There was, happened to be watching the last few days of the legislature on the monitor in my office, and a member of the House stood up and made a floor speech and then immediately stood up afterwards and said she'd been advised to declare a conflict of interest, and then went on to tell everybody that she was part of a class. Are the rule, does House rule deal with class for legislators versus statute for other public officials? Or, and if you need time to answer that, please don't feel like you have to answer it
No.
today, but
I issued a letter of advice last month. It was in your last book. It was to Senator Reynolds.
this was not that case.
Right.
This was a,
But it's the same thing, which is, of course, that for the legislature, while 244-120 does say, does apply conflicts of interest, it also says they get to adopt their own rules, and they have. So for the most part, because of the constitutional provision that when the legislature is debating, the speech and debate clause, that we have no jurisdiction over them. So they have their own process for disclosing their conflicts. The question that came to us in the Lisa Reynolds letter was that normally it's only the commission that can determine whether there is a class or a class exception would apply. But the determination of class only applies to the determination of, do I need to disclose a conflict? And since we have no authority over a legislator's determination of whether they need to disclose conflict, in my discussions with Tim Zakarek at the legislature, we reached the determination that we couldn't say you're a member of a class or you're not, because really that is only relevant to their conflict determination and enforcement.
Commissioner, follow-up at all?
good, thank you.
Colleagues, any other comments or questions? I've got just a couple things to say. Denials, like on lack of hands or anything else, I'll just make these comments. First of all, I, as one commissioner, will always be hesitant to declare there to be a class without the benefit of staff analysis about that issue to iron out all the issues therein. That's just my outlook as the issue of class. It has come up in the past, or will come up in the future. Second question is there anything that we could or should consider doing to enunciate our policy on considering class in advance of this particular issue coming up, such as a memorandum or an advisory opinion or a summary in writing in some way? I yield to you, Executive.
Which is a very nice segue to my next topic, which is rulemaking. And so Casey here is drafting rules. We are doing rulemaking this fall to update and improve the ethics administrative rules. And in that process, we are going to propose a rule that at least sets forth for public officials some of these processes for class extensions. So sets forth that the requirement, if you want an official determination, this is the best way to go about doing it.
Thank you. That answers my question. We'll rely on investigator, Finster maker for that analysis at the proper time. I was going to say one other thing and I forgot what it was, which means it's not important.
So then
So please continue on point number, the third bullet there. Thank you.
So yes, we are working on updating the ethics rules, including kind of the compliance and process and making them more useful, readable. So one of those topics kind of touches on comments that Chair Fiscum has made and a discussion with Commissioner Mason, which is the penalty matrix and the penalties imposed by the commission. So the laws that we deal with set forth the maximum penalties, but we have, by administrative rule, adopted that penalty matrix. So the question is, do we amend the penalty matrix, or do we, as Commissioner Mason suggested, should we go back to the legislature and have them amend the maximum statutory penalties, or both? In terms of going to the legislature, that is, it's up to you whether you want to do that. In my discussion with Chair Fiscom, one of the questions, or I think with Commissioner Mason, sorry, one of the questions was, should the ethics statutes have more than a $5,000 penalty? And I do know that when I went to the Kogel conference a couple years ago, a couple years in a row, there are entities that are there, like the Chicago Ethics Commission and others that have, they do have an ethics commission.
That's funny for me.
And not only do they have an ethics commission, but their penalties are much higher. My memory is it was like $20,000 or $25,000 per violation.
Yeah.
But a lot of the ethics commissions also operate more on the criminal side. And so it's not that easy to make a direct comparison, but it could be worth considering. It's been 5,000 for a long time.
Yeah, and I would only add just a quick comment. It's been 5,000 for a long time. And as a commission, in my experience, we rarely reach that level, for better or for worse, for good or ill. But at the same time, I'm in favor of reviewing the entire penalty matrix to bring it, quote, up to date, unquote, whatever that means, Ms. Fenstermaker. That's your challenge to propose to us. So that's good. Commissioner Mason, please, I'll say your hand.
Thank you. I just asked if the executive director knows how long it's been set at 5,000. Are we talking about since the 90s, since the inception in the 70s? I mean, do you have a rough time, or maybe it's only in the last decade?
I don't have an answer. I can look into that. Yeah, I don't know. I'll find out.
Thank you.
Thank you, Commissioner. Any other questions or comments on this last issue on our work session? Or if anybody has other comments on the other matters, we'll still take them in the next moments. The moment seeing no hands, we will move on from the work session executive. Is that acceptable? Okay.
Yes.
The last item we'll review on the public session agenda is the review and potential approval of minutes of the June 13, 2025 meeting. Those have been distributed to all of you. Any comments on those minutes as sent? Hearing and seeing none, I'll take a motion to approve them as distributed. Vice Chair.
Mr. Chair, I move we approve the minutes of the June 13th meeting as distributed.
Thank you. Any comments? Hearing and seeing none, the administrator will call the roll, please.
Commissioner McCauley,
Aye.
Commissioner Thompson,
Aye.
Commissioner Resendez Gutierrez,
Aye. Aye.
Commissioner Jancy,
Aye.
Commissioner Mason,
Aye.
Chair Fiscom.
Aye.
Motion passed 6-0.
Thank you. Okay, colleagues, before we move into executive session, two questions. First, does any commissioner need to declare a potential or actual conflict of interest pertaining to a matter on the executive session agenda? If so, now is the time to make such a declaration during the public session. Commissioner, I see a hand. Who is that? Is there a hand up?
That's Commissioner Burke.
Mr. Burke, please. Mr. Burke, can you hear me? It looks like you're on mute. Mr. Burke? Wait a second to see.
It's *6 to unmute Commissioner Burke.
Mr. Burke, if you can hear us, it's *6 to unmute.
I'm sorry, Mr. Chair. I just
Please.
wanted to register my vote as aye and let you know that I did check into the meeting.
Oh, thank you very much, Commissioner. Appreciate it. That's helpful. Any other comments on, in response to the need to declare it for a declaration? Hearing and seeing none. The second comment is our staff is maintaining a list of representatives of the news media who have told us they will attend the executive session under provisions of state law in Oregon. Are there any questions about that media list? Please.
Yes, there is one, actually, no. Right now we have Jane Vaughn from Jefferson Public Radio and Diane Lugo from the Statesman Journal. Everyone else is, there are no questions. So thank you.
Thank you. So let's move into executive session, but one brief reminder again, which applies to everybody in the room, maybe especially me, or at least me, because our technology is sensitive enough, it can pick up all kinds of private conversations, especially as we're involved in the technological process of admitting persons into executive session or removing them. Please be careful about such comments because even in a low voice, those can become part of the official record. So before the on-site and virtual doors are closed, I'll read for the record the specific statutory authority in Oregon that enables us to proceed in this way. And as I have said before, credit goes to our staff and our counsel for drafting this authority with appropriate specificity, if for no other reason than that we hold other government organizations accountable to cite the proper statutory authority for their executive sessions. So we need to be very precise and accurate in our own citation. Thus, herewith are the words. The Oregon Government Ethics Commission will now meet in an executive session to consider preliminary reviews and a separate executive session to consult with legal counsel concerning the commission's legal rights and duties with regard to current litigation or litigation likely to be filed and to obtain confidential legal advice. Representatives of the news media and designated staff shall be allowed to attend the executive session. When we enter executive session, all other members of the audience will be asked to leave the room. Everyone currently joining the meeting online or over the phone, other than representatives of the news media, will be removed from the meeting. If your case is being heard in executive session, you will need to rejoin the meeting where you will be held in the virtual waiting room until the commission is ready to hear your case. Our staff will text you on the number you provided them to let you know when we are about to hear your case. The first executive session is being held under ORS 192.660 sub 2 sub F and ORS 244.260 sub 4 and ORS 192.685 sub 1 to conduct preliminary reviews of ethics and public meetings law complaints. Representatives of news media are specifically directed that after the commission has made its final determinations and adjourned the executive session, they may report on their preliminary review cases, items 1 through 16 on the executive session agenda, including the commission's deliberations and its final determinations. ORS 244.260 sub 4 sub D sub C authorizes the commission to deliberate and make its final determinations on preliminary reviews in executive session. Following the conclusion of the meeting, the commission will publicly disclose and post the audio and video recordings of the preliminary review executive session. The second executive session, item 17 on the executive session agenda, is being held under ORS 192.660 sub 2 sub H and ORS 192.660 sub 2 sub F for the commission to consult with its legal counsel concerning its legal rights and duties with regard to current litigation or litigation likely to be filed and to obtain confidential legal advice. No determinations will be made in the executive session. Representatives of news media are specifically directed that they may not report on or otherwise disclose any of the deliberations or anything said during this separate executive session. The audio and video recordings of this separate executive session will not be posted or publicly disclosed. Once both executive sessions are concluded, we'll return to open session and welcome the audience back into the room. Finally, as I said before, if any of the commissioners have conflicts of interest on any matters being heard in executive session, the time is now before the doors close to make your disclosures, and we have not seen any so far. So we will now enter the executive session officially. Thank you. Colleagues, we will now consider, right. We'll hold till you're ready, but we're going to move into the executive session portion of our agendas. And we will proceed as soon as our staff says we're ready technologically.